Visit our website, amvpsolutions.info, and Facebook page, Aussie Migration and Visa Professional Solutions.
You might think that OSHC is optional and not needed, right? Think again. OSHC, or Overseas Student Health Cover, is a health insurance for international students that covers out-of-the-hospital medical treatment, in-hospital medical treatment, prescription medicines, and emergency ambulance transport. The Australian government, through the Department of Home Affairs, requires all student visa holders to maintain OSHC during the entire stay. Otherwise, visa may be refused or cancelled. You need to have an insurance provider to cover for you. At AMVPS, we assist and provide information in finding the best insurance provider that fits your needs. We help you to make informed decisions about your healthcare while studying in Australia. Student Visa Condition 8501 states that overseas students who do not maintain OSHC are at risk of having their visa cancelled. Are you eligible for OSHC? Yes. Overseas students are eligible for OSHC. You are an overseas student if you are a person who is a holder of a student visa, or a person who is a student visa applicant and is a bridging visa holder and was immediately before being granted the bridging visa, the holder of a student visa. Your certificate of insurance will show which policy you have selected. For example, your policy may be either single, dual family, or multi-family. AMVPS is a partner with trusted insurance OSHC providers in Australia. OSHC saves you time and money, so you won't have to worry about the expensive medical bills should anything happen to you in the future. Get your OSHC policy today with AMVPS. For assistance, visit our website at amvpsolutions.info and like us on Facebook at Aussie Migration and Visa Professional Solutions.
One of the best feelings in life is having moments with the ones you love, even if you're far away from each other. Despite being 1,000 miles apart, our feelings haven't changed. Being beside you is a wish that I've long desired. With professional help, the long wait is over. Bridge the gap with Aussie Migration and Visa Professional Solutions. You can study, work, or live in Australia. With the help of our experts, you can fix your migration and visa application efficiently. Now, love doesn't have to be distant. Call us now.
A dream. Everyone has it. Distractions are everywhere. which makes us feel far from our dreams. Now, there is a way to close that gap. With AMVTS, we can take the one less travel by. And that has made all the difference. Whether big or small, our dreams are there to take us to write our future. Be a scholar now. To learn more, visit our website at amvpsolutions.info. Like us on Facebook at Aussie Migration and Visa Professional Solutions.
Currently, just this week, the Morrison government made additional 5 changes. So what are these 5 changes? The first one is that offshore student visa applications are now allowed. So before this announcement, there was a confusion whether or not student applicants who are still outside Australia can lodge their student visa application. So now, it has been made clear that the Department of Home Affairs will process and decide whether to grant or refuse a student visa application lodged offshore. And if the decision is a student grant, then they can come to Australia once the borders reopen. As we know, it's still uncertain when is the exact date for the opening of the borders. There are student visa applications, but there was no clear policy about it. So now it has been clear that student visa applications lodged offshore can be processed, and the department can grant or refuse the same. So aside from that, Claudette, the other changes made is that for those onshore students who did not finish their studies within the period of their original visa because of the COVID-19, if they will apply for the visa extension, the Department of Home Affairs has waived the visa application charge. The visa application charge is the amount of money the department will accept for them to process the visa application. This waiver of the visa application charge will apply only for those whose studies was not completed because of the COVID-19. So the third change, this will only apply to current student visa holders who are studying on a bachelor level or master's level. The student was outside Australia, and then they cannot come back to Australia because of the closure of the borders. So while they are doing their online studies outside Australia, the duration of that online studies conducted offshore can be used for purposes of counting the number of weeks for them to comply with the Australian study requirement. The importance of the Australian study requirement is relevant to the 485 or the so-called temporary graduate visa under the post-study stream. And then the fourth change is the temporary graduate or the 485 visa under the post-study stream can be lodged even if the applicant is outside Australia. So if the applicant cannot come to Australia because of the closure of the borders, and then their student visa is about to expire, and they are eligible for the temporary graduate 485 visa under the post-study stream, they are now eligible to lodge it even if they are outside Australia. In this visa, they should lodge it here onshore. And then the last one to that is that the Department of Home Affairs has given additional time for those who are required to provide English language test results because of the pandemic. So If you have lodged your visa and you have not yet taken your English test, you are not required to attach the English test result simultaneously with the lodgement of the visa. The department will accept a proof of booking, and that will be enough. But as soon as you have the English test result, you should attach it also to your application so that they can make a decision. Currently, just
Good day, everyone. Thank you for attending today's information session about partner visas, particularly spouse visas, which can either be lodged onshore or offshore, and prospective marriage visas or the so-called fiance visas. So let's look into the definition of what is marriage under Philippine laws so that we can make somehow a comparison about what is marriage in Australian laws, what is the definition of a spouse in Australian laws. So, under the family code, marriage is a special contract of permanent union between man and a woman enacted in accordance with law for the establishment of conjugal and family life. Later on in our discussion, you will see the difference as to the construction of the sentence of the definition of what is a spouse in Australian laws and in Philippine laws. So these are just some of the information that you will learn in throughout this information session. So let's also discuss what are the reasons why people enter into marriage. Know that not all are of the same age when they enter into marriage. Now, well, primarily the main reason why people enter into marriage is because of love, but there are also other reasons. And the other reason could be number one is for companionship or for a long-term lifetime commitment. The other reason could also be for religious beliefs. Other reasons could also be for like how marriage is defined in the Philippines. Other reason is for procreation to have children, and other reason for could also be for economic stability and legal status. So let's start our discussion. I will share to you my screen. I got this some of the notes in my practical legal training, which is a requirement for the renewal of my registration with the Migration Agents Registration Authority. So allow me to share. There you go. So as you can see, these are the main topics that we will be discussing throughout today's information session. You can see here three categories, the 820/801 visa. This refers to the onshore application. In a spouse visa, this is a two-tiered visa, one application only, but there are two subclasses, the 820/801 or the 309/100. So this is a continuous application. And what is the main criteria that needs to be proved here? It is the genuineness. It is the genuineness and the continuing relationship to the exclusion of others. But there are also other criteria that needs to be met. But I'm trying to tell you that although these are different subclasses, they are only considered as a one application, but on a two-tiered application. On the other hand, the prospective marriage visa is the so-called fiance visa, and this cannot be lodged onshore. The applicant must be offshore. The 309/100 visa is a spouse visa, and the applicant at the time of the application is outside Australia. On the other hand, we will also be discussing about sponsorship requirements. Take note that on a partner visa, the requirement is that the sponsor must be an Australian citizen or a permanent resident of Australia and also an eligible New Zealand citizen. We will discuss later on what is the definition of how can a New Zealand citizen be considered as an eligible New Zealand citizen. We'll also be discussing about the health waivers and what are the health requirements as a public interest criteria. We will also define the spousal and a de facto relationships. Take note that in the Philippines, we don't have this de facto relationship registration, but in Australia, they consider that, and couples or partners who are in this relationship are recognized by the government. And lastly, of course, we also discussed the concept of family violence in relation to the visa application. To formally start, partner visas or the so-called fiance prospective marriage visa or spouse visa are part of the family stream of migration. Together, they contribute to approximately a little under 25% of the total migration program for the current financial year. It is expected that this year there will be higher, or the processing period will be faster compared to the previous years because this has been considered as a priority visa as of the moment. Now, I mentioned a while ago the prospective marriage or the fiancé visa, and this is an offshore visa where the applicant is engaged and not married yet to an Australian citizen, a permanent resident, or an eligible New Zealand citizen. On the other hand, the spouse visa, be it either the 309-100 or the 820-801, the applicant and the sponsor are already married. So for the 309 and 100, the applicant is still outside Australia. On the other hand, for the 820 and 801, the applicant is already in Australia. It could either be on a valid visa or without a valid visa, but there is a sponsor, an Australian citizen or an Australian permanent resident or an eligible New Zealand citizen. So I'd like to emphasize that even if you are not holding a valid visa in Australia, but you fell in love or you want to, or you have married an Australian citizen or an Australian permanent resident, then you can also be eligible to apply for a partner visa, even if you don't hold a valid visa at the time of the application. Now, let's discuss first the prospective marriage visa. The subclass number for this is 300. And as I mentioned a while ago, this is the so-called fiancé visa. Now, at the time of application, the applicant is engaged. And what must be shown to the case officer? The applicant must show evidence that they have a genuine intention to marry their sponsor and live together in Australia. So the basic understanding of prospective marriage visa is you will come to Australia, establish the genuineness of the relationship, the genuineness of the intention to marry when you are, or when you will be granted a visa in Australia and live together. Take note that the requirement here is that upon the grant, you are given 9 months to get married. And then upon married, then you can apply for the spouse visa onshore application. Now, let's continue. The sponsor must be an Australian citizen, a permanent resident, or an eligible New Zealand citizen. This requirement is also applicable for spouse visa offshore application and spouse visa onshore application. Now, what is an eligible New Zealand citizen? An eligible New Zealand citizen is a person who was a New Zealand citizen and had been present in Australia on or before the 26th of February 2001 as the holder of a subclass 444 visa, or someone who was the holder of a subclass 444 visa for a total of at least 1 year between the 26th of February and 26th of February 2001, or has had a certificate issued by Centrelink stating that they meet the relevant dates to be recognized as an eligible New Zealand citizen. So take note that the word eligible has a technical definition. So not all New Zealand citizens are considered as eligible New Zealand citizens because that person must be present in Australia on or before the 26th of February 2001 as the holder of a visa subclass 444. Now, aside from that, the other requirement is that the sponsor, who is the Australian citizen or an Australian permanent resident or an eligible New Zealand citizen, must be over the age of 18. So that's the general rule. If under 18, then the Australian citizen must, if under 18, an Australian citizen, permanent resident, or eligible New Zealand citizen parent or guardian must be the sponsor. So take note that the sponsor, if the Australian is under 18, can be the parent or the guardian. But it must be shown that at the time of marriage, the applicant, the Australian citizen, must be over the age of 18. Otherwise, they will need to obtain permission from an Australian court authorizing the marriage to take place within 3 months after the permission has been obtained. In the Philippines, the age requirement for one to enter into a valid marriage is 18 years old. So, same with Australia. Now, for one to be able to apply for a prospective marriage visa to get married in Australia, both parties must not be married to anyone else, meaning they must be capable of entering into a marriage, or they must not have been married to anyone else or in a prohibited relationship. Sample of a prohibited relationship could be if you marry your brother, you marry your sister or your cousin. So that is a prohibited relationship. Okay. Conditions. The applicant must be outside Australia at the time of the decision and must hold a valid passport unless it is unreasonable for them to do so. Now, there are instances where applicants of a prospective marriage visa and also applicants of prospective marriage visa, before the decision of the subclass 300 application, entered Australia on a visitor visa. Now, this has been a concern at present because they must be outside Australia at the time of the decision. And because of the pandemic, they're stuck. So there are many groups now lobbying to somehow amend this particular provision so that they need not go out of Australia to have the decision be granted. Now, aside from that, another condition is that the applicant and the sponsor must not marry before entering Australia. So, in this, the situation here is that the visa has already been granted, and the visa has a condition 8515. They must get married inside Australia. Now, if they marry outside Australia and after the grant, then that is a violation of the condition 8515. Is there a remedy? Yes. If they do so, then they must notify the department and move to a spouse visa will be taken to have been made. Why is this so? It's because the main purpose of the prospective marriage visa is for you to enter Australia to have a legal status in Australia as a visa holder for purposes of getting married. So if you marry after the grant and before you enter Australia, then that defeats the purpose already. So, but if you get married outside Australia, then the remedy is for you to just notify the department so that you can apply for the or we consider that a spouse visa will be taken to have been made. Now, as mentioned also in relation to the purpose of getting married while you will be in Australia on a valid visa, there is a time period and you must get married within 9 months from the grant of the visa. And this is not extendable. Other conditions will be 8520, 8502, and 8515. These will be imposed upon the secondary applicants. Now, who are the possible secondary applicants? These can be the children of the applicant. And take note that the Medicare will only be available once they lodge their permanent spouse visa. So if you have been granted a fiance visa and then you are here in Australia, you cannot be granted or you cannot apply for Medicare. When can you apply for Medicare? Only upon the lodgement of the permanent spouse visa. Okay, now let's proceed with partner visas. Now, who is a spouse? A spouse is defined under Section 5F of the Migration Act. And it states that a person is the spouse of another if the two persons are in a married relationship. Now, the other definition that we need to know is the definition of what is a married relationship. Now, that has been defined under Section 5F, Paragraph 2. For purposes of the subsection 1, persons are in a married relationship if, number 1, they are married to each other under a marriage that is valid. So not all marriage can be valid. Only a valid marriage can make a person be considered a spouse. And second, they have a mutual commitment to a shared life as husband and wife to the exclusion of all others. And third, they are in the relationship between them is genuine and continuing. So as you can see, there are two words here that you need to know. Genuine. What constitutes genuine? Genuine means true, not fake. And continuing. This refers to the time element. So continuity of the relationship refers to the duration, the period. And aside from that they live together, or if they are living in a long distance if they are in a long distance relationship, such long distance relationship should not be on a permanent basis. So again, a visa applicant is a spouse if they are married to an Australian citizen or an Australian permanent resident or an eligible New Zealand citizen, and the marriage is valid and they have mutual commitment to a shared life as husband and wife to the exclusion of all others. It's not a bigamous marriage. And the relationship between them is genuine and continuing. Genuineness here refers to the truthfulness, while continuing here refers to the time element, and that they have lived together. Or if they have been in a long distance relationship, that arrangement, the long distance relationship, is not on a permanent basis. Now, what about de facto spouse? It has been defined under Section 5CP. A de facto partner is a person is the de facto partner of another person. Take note whether of the same sex or a different sex if the person is in a de facto relationship with the other first person. Now, as I mentioned earlier, this type of relationship is not recognized in the Philippines, but in Australia, it is recognized. But not all states allow couples who want to enter into a de facto relationship have their relationship be registered. In Perth, I've learned that there are couples there who are not married, but they want to apply for a de facto relationship, and the problem there is that it's very difficult to prove. You need to have a lot of evidences. Why? Because the state of Perth, Western Australia, do not allow registration of a de facto relationship. On the other hand, in Victoria, um, couples with an Australian sponsor or Australian permanent resident sponsor and a visa applicant can register their relationship as a de facto uh, spouse or in a de facto relationship. Now, that is why the rule here is that if you want to establish that you are in a de facto relationship and you are a de facto spouse, then you must establish compelling and compassionate circumstance. And the minister must be satisfied that the applicant has been in a de facto relationship for at least a period of 12 months, ending immediately before the date of application. But the 12-month rule does not apply if the de facto relationship is a registered relationship. So if you have registered your relationship, then you need not to establish, you need not uh, comply the 12-month period before the date of the application. Now, what about long-term spousal relationship? Now, this is important. Why? Because it can speed up the processing of your spouse visa application. Um, the definition of a long-term spousal relationship is for a period of not less than 3 years. So, not less than 3 years means 3 years and more. So, if you are in a relationship that is 3 years or more, then the 2-year provisional period between the lodgement of the temporary partner and the grant of the permanent visa will be waived, and the couple will go on the permanent stage straight away. Now, what does this mean? It means that you need not satisfy the 2-year provisional period because you have the case officer um, is convinced that you are in a long-term spousal relationship. Now, what is then the purpose of the 2-year provisional period? The purpose of this is to let the time uh, continue and see whether the relationship will not break down. Because if the relationship will break down within the 2-year provisional period, then um, there can be an impact to that with your spouse visa application. So again, if your relationship with the Australian citizen or Australian permanent resident is 3 years or more, and you have several documents to attach to prove that indeed you are in a long-term spousal relationship, then the 2-year provisional period between the lodgement of the temporary and the uh, grant of the permanent visa will be waived, and the couple will go on to the permanent visa straight away. It's because it's like this. So you know that there are two visas, yes, subclass visas, the temporary and the partner. So the 2-year provisional period will be counted from the start of or immediately after you lodge your provisional or the temporary visa. And then you need to wait for 2 years before you can apply for the permanent visa. And as I mentioned, the purpose of that is to see if the relationship will not break down during the 2-year provisional period. If the relationship will break down, then that means you cannot proceed with the permanent visa. Now, let's discuss these criteria. As I mentioned a while ago, I have emphasized that the main criteria is that the relationship is genuine, continuing, and exclusive of all others. Now, marriage is the best proof that the relationship is genuine because when you enter into marriage, you're not just there for feelings. There are corresponding obligations attached to marriage. Like you have obligations to your wife, you have obligations to the state, and you have obligations to your children. And that is what marriage is all about. It's about obligations and fulfilling your obligations. And the main purpose, as I mentioned, the main criteria rather, is that the relationship is genuine, continuing, and exclusive of all others. Now, genuine, the truthfulness, continuing, the time element, and all exclusive of all others. Meaning you have no other marriages and your relationship is you are committed only to one person and that is your spouse. Okay. So whether married or de facto, it is part of regulation 1.15a that evidence of the genuine and continuing relationship that is exclusive of all others exists. These can be shown through four main areas which the applicant should show through evidence to be submitted. And these are the financial aspects of the relationship or the so-called economic aspects, the nature of household. When we say nature of household, this can be how you live together as husband and wife. So who do the cleaning, who do the um, washing of clothes, cleaning the house, cleaning the backyard, who do the grocery, and also the nature of the couple's commitment to each other. This can be exemplified through what are your plans in the next 10 years? You want to have how many children? So, and also the social aspects of relationship. How do you show yourself to the public that you are a couple? And how okay, so financial aspects of the relationship. So these are just some of the evidences that you can use. So if you don't have it, you don't need to force yourself because if you submit a document, for example, a joint bank account, but it has just been recently opened, then that can only cause confusion to the case officer. So I'm trying to emphasize is that if you don't have a joint bank account, you need not be stressed why you don't have such and then you cannot attach it in your application. Because if you have just recently opened your bank account at the time you lodge your spouse visa application, then the case officer might think that this document does not really support a lot because it has just been opened recently. So take note that the case officer will look into the genuineness and the continuity of the relationship. So aside from the joint bank account, you also have joint loan agreements for real estate, cars, major household appliances, or any other agreements related to finances or purchase. The other one would be pooling of financial resources, and the other one could be the legally binding financial obligations and sharing of the day-to-day household expenses. Now, let's proceed with the nature of household. So, this can be established through joint ownership of property, joint residential leases, joint rental receipts, joint utilities accounts such as gas, water, and telephone. Others would be correspondence going to the same address for either or both the applicant and sponsor, shared responsibility for the children, and shared responsibility for the housework. I think these are self-explanatory. Joint ownership of property, the best evidence that you could attach to this would be the proof of ownership, such as the title, the land title or the car registration, contract maybe, residential lease, the contract of lease, receipts, proof of same address, maybe mails. Okay, now let's proceed with the social aspect of the relationship. Now, there are there is a requirement of having two witnesses who will fill the form 888. And that requirement is to comply with the social aspect of the relationship criteria. And that form 888 is a statutory declaration form in a statutory declaration form. Now, aside from that, you need to present if you have joint travel plans in the past and in the future. Joint membership of organization. For example, you are going to one church, then you can also use that one to prove that you are in a genuine and continuing relationship. And evidence that the relationship has been declared to the government bodies, commercial or public institutions. And of course, the most important one, I believe, is the nature of the commitment. Now, you need to establish here the duration of the relationship, the length and time the parties have lived together, the degree of companionship and emotional support, whether the parties see the relationship as long-term, the parties' knowledge of each other's family background, and the evidence of the intentions to make relationship long-term. In your spouse visa application, you need to somehow write a small love story just to present to the case officer the nature of the commitment. So that love story document will support this criteria, the nature of the commitment criteria, to establish the genuine and continuing relationship to the exclusion of all others. Now, let's proceed with the sponsorship requirements. Now, we all know that the visa applicant and the sponsor are not on equal footing, but it must be established that the sponsor also has his obligations. The sponsor has obligations towards the visa applicant. And as to the time element, if the applicant is in Australia, be it through the prospective marriage visa, during the period of 2 years immediately following the grant of the provisional of the temporary visa. Or if the applicant is outside Australia, during the period of 2 years immediately following the applicant's first entry into Australia. Now, what obligations can you think of? I think the main obligation is the economic obligation. Take note that you sponsored somebody who is outside Australia to come with you, to live with you, and give up everything what he have in his or her home country. And I think it is important to support the economic and the social or psychological of the visa applicant, because it's not easy to leave everything behind in your home country and come to Australia to be with you, to live with you, and it's not simple. If you're really in a genuine relationship, the sponsor must recognize that you have obligations towards the visa applicant, considering that Australia is a new country and migrants really suffer for culture shock, adjustment with the language, adjustment with the culture, and everything. So as to the time element, as I mentioned, if the applicant is in Australia during the period of 2 years immediately following the grant of the provisional, or if the applicant is outside, now the 2-year period will start from the date of the applicant's first entry. Now, limitations on sponsorship. What does this mean? It means that the sponsor, who can either be the Australian citizen, the Australian permanent resident, or the eligible New Zealand citizen can sponsor more than one applicant. Now, question, can the sponsored visa applicant sponsor later on? Now, the answer would be yes. Now, let's discuss Regulation 1.20J. If the sponsor has previously sponsored a partner, whether it be a prospective spouse, or a de facto spouse, and the visa was granted, 5 years must pass from the date of the first application was lodged to the date the second application was decided. However, there are waiver provisions. So this means that there is a bar period. So if you sponsored a partner, you cannot sponsor within 5 years from the date the first application was lodged to the date the second application was decided. Now, however, if the sponsor has already sponsored two different people and those visas were granted, take note, the two applications were granted, they will be prevented from sponsoring a third applicant. That's the general rule. They will be prevented from sponsoring a third applicant unless they receive a waiver of the sponsorship limitation. So basically, the general rule is that an Australian citizen, Australian permanent resident can sponsor two applicants. They cannot sponsor a third applicant if the second application is granted. And the other one, they can sponsor, on the other hand, they can sponsor a third applicant if they receive a waiver of the sponsorship limitation. So again, the maximum number of people that a sponsor, an Australian citizen sponsor, can sponsor is only a maximum of two. And within these two, with these two people, there is a 5-year gap. And the 5-year gap will be counted from the date of the first application to the date of the decision of the second application. Now, if the sponsor has already sponsored two different people, can he still sponsor a third one? The answer would be, it depends whether he has a valid reason under the compelling and compassionate circumstances and his waiver has been accepted. So, I mentioned a while ago that the person who has been sponsored in Australia, can they sponsor another person? The answer would be yes, but there is a gap. There is a bar as to the number of years. If the sponsor were themselves sponsored to Australia, 5 years must pass from the date of their application was lodged. These requirements can be waived if the sponsor can show compelling and compassionate circumstance. Now, let's proceed with the public interest criteria, health, and character. Now, take note that this criteria is not only for the primary applicant, but also for the secondary applicants and even family members who may not even be migrating for all visa subclasses. Now, what does this mean? What does the public interest criteria, health, and character means? It means that the applicant is free from tuberculosis and is free from a disease or condition that is or may result in the applicant being a threat to the public health in Australia or a danger to the Australian community. So take note, the applicant must be free from tuberculosis and is free from a disease or condition that is or may result in the applicant being a threat to the public health in Australia or a danger to the Australian community. This is the reason why before you be granted a visa, you need to undergo medical examination to protect the Australian community. Okay, let's continue. And subject to subclause 2 is not a person who has a disease or condition to which the following paragraphs apply. Number 1, the disease or condition is such that a person who has it would be likely to require healthcare or community services or meet the medical criteria for the provision of the community service. And during the period of the applicant's proposed stay in Australia, the provision of the healthcare or community services relating to the disease or condition would be likely to, number 1, result in a significant cost to the Australian community in the area of healthcare and community services, or prejudice the access of an Australian citizen or a permanent resident to healthcare or community services. So these are the grounds for you not to meet the public interest criteria. If the case officer is convinced that the period of the applicant's proposed stay in Australia will result in a significant cost to the Australian community in the area of healthcare and community services, or prejudice the access of an Australian citizen or permanent resident to healthcare or community services. And take note, regardless of whether the healthcare or community services will actually be used. So regardless if you will use it or not, then you can still be subject not to be able to comply with these required criteria. On the other hand, if the applicant is a person from whom a medical officer of the Commonwealth has requested a signed undertaking to present himself or herself to a health authority in the state or territory of intended residence in Australia, the applicant has provided such undertaking. So take note that the applicant can access a health waiver as well. If the applicant, again, I'll read, if the applicant is a person from whom a medical officer has requested a signed undertaking to present himself or herself to a health authority for a follow-up medical assessment, the applicant has provided such undertaking. Now, who is the medical officer of Commonwealth? Now, this is the person who will determine whether an applicant's condition or disease would be likely to prejudice the access of Australians' healthcare and community services. Now, how will the medical officer of Commonwealth assess or determine the applicant's condition? Now, he will look into the level of prejudice. Now, the standard is the level of prejudice will be substantial or extensive. So if it's substantial, then unfortunately the applicant cannot meet the public interest criteria. Now, what constitutes substantial or extensive? Now, this includes the following. Number 1 is the organ transplants. Number 2 is blood plasma products, recurrent use of blood and blood components for people with rare blood groups, radiotherapy, dialysis, interferon treatment, nursing and residential care, and also treatment for active hepatitis. Now, take note that it will be irrelevant whether the applicant will use the services or not, as the medical officer of Commonwealth only needs to assess the applicant's condition. Now, aside from that, the medical officer of Commonwealth must determine whether an applicant's condition or disease would be likely to result in a significant cost to the Australian community in the area of health and community services. Now, how will the medical officer of the Commonwealth determine through this, determine the applicant's condition or disease would result to a significant cost? What constitutes significant cost? Now, as of the present, the calculation now is for over 10 years. And, sorry, the cost threshold is 49,000 Australian dollars. So that is the how that is this is how the medical officer of Commonwealth determine what constitutes significant cost. If the significant cost is more than 49,000, then you fail to meet the public interest criteria, the health requirement, and the calculation is for 10 years. Now, the example to this would be if the visa applicant is with HIV, the calculation is 135,000 for 10 years. So unfortunately, the applicant with HIV cannot meet the public interest criteria health requirement for failing to comply with it, because the current threshold, the cost threshold is up to 49,000 Australian dollars for 10 years. And take note again that it will be irrelevant whether the applicant will use the services or not. Now let's proceed with the last topic for today's information session, which is family violence. Now, for prospective marriage visa, if the visa applicant is already in Australia and before they apply for the partner visa, the relationship ended, and the reason for the breakdown of relationship because of the violent behavior of the sponsor, then the applicant cannot seek remedy in relation to the family violence provision. If the relationship ends before the marriage takes place, there are no provisions that enable the applicant to stay in Australia, except if they're eligible to apply for a different visa. So, scenario here, if you want to apply for a student visa and then you meet the criteria, the requirements for the student visa program, then you can apply. Or if you're highly skilled, then you can apply. Now, question: what if you meet an Australian citizen and then you want to get married? Will there be no problems? Now, the answer would be the applicant will encounter difficulties as the definition of the sponsoring spouse is the same sponsor as on the prospective marriage visa. So take note that you are in Australia to get married to the original Australian citizen or the original Australian permanent resident sponsor. So therefore, you will have problems if you will apply later on for a partner visa, if you are here in Australia on a prospective marriage visa. Now, what about during partner visa applications? Or what about for spouse visa applications? Now, after marriage, so that could either be a spouse visa lodged offshore or spouse visa lodged onshore. If the family violence or death of the sponsoring spouse occurs, then the applicant may still be eligible for the visa grant. Now, take note: this does not only apply for family violence but also for death. Now, what if while the applicant is on a subclass 309 and in Australia, or subclass 820 in Australia on a temporary visa, and then the sponsor died? What's the remedy? And the answer to that would be you can still be eligible for the visa grant, provided that You can prove the relevant criteria, the nature of commitment, the financial aspect, and the genuineness and the continuity to the exclusion of other main criteria, as well as proving that the relationship was genuine at the time that change in the circumstances occurred. So if unfortunately your sponsor Australian citizen or your sponsor Australian permanent resident died while you are still on the um, temporary or the provisional stage, then you can still be eligible to apply for the visa grant for the permanent stage, provided that you can prove that the relationship at the time of death was genuine and continuing. Now, what if the spouse or the Australian sponsor, Australian permanent resident died after you uh, have or after you were granted the permanent visa? Then your visa status will not be affected because you're already a PR. So if you are already on the subclass 100 or you are already on the subclass 801 and your partner died, then your visa will not be affected. Why? Because your visa is already a PR visa. You are already a permanent resident visa holder. Now, let's proceed with the concept of family violence. Let's go back again with the family violence. Who must be the alleged perpetrator? Take note that the alleged perpetrator must be the sponsoring spouse. And if it is a family member of the sponsoring spouse, then this will not meet the criteria. So the sponsoring spouse must be the alleged perpetrator. When we say alleged perpetrator, he is the one who allegedly committed the violence in the family. And take note that it is important to remember that the family violence provisions can only be enacted once the relationship has ceased. If the applicant and the sponsor still live together, but in separate parts of the house, it will be very difficult to prove that the relationship has ended. I think everybody knows that a relationship is not a relationship if there are no quarrels, if there are no disagreements and everything. That's part of the contract, the special contract that you entered into. As marriage is a decision, it should not be based on feelings. So take note again that the family violence provisions, you can only use this one, uh, can only be enacted rather once the relationship has ceased. So if your partner, if your sponsor partner has been violent to you, be it economically, psychologically, physically, and then you still live together, then you cannot avail of these provisions. Now, evidences. What are the evidences that you can present, that you can attach to the case officer so that even if the relationship has already ended, you can still apply for, you can still be eligible for the partner visa. Now, one is a final court order issued against the alleged perpetrator in relation to the restraining order, protection order, injunction order. So the final court order here is not in relation to the main case, but in relation to the restraining order, protection order, or the injunction order, such as an apprehended violence order. Another one would be a conviction of assault or some other violent offense from the alleged perpetrator against the alleged victim. Now, when we say conviction, the case has been finally decided and is finally determined. When we say convicted, meaning to say you already have no remedy of appeal, the decision is final. And the third one is the joint undertakings by the alleged victim and the alleged perpetrator filed in court proceedings where there was an allegation of violence. So if the perpetrator issues a joint undertaking together with the visa applicant, then that can be considered as a evidence. Now, family violence, I haven't included in the slide, but this does not only refer to physical violence. It can refer to economic violence or psychological. violence. So I think that's all for today. Thank you so much for listening, and I hope to see you soon all again next time. For the next information session, we'll be focusing on spouse, children of student visa holders, and also whether it's nice to have a combined application or subsequent applications for the dependents of the student visa holders. So thank you once again, and I hope to see you soon. Bye bye.
If you had a dream, chase for it. Simulan mo na abutin. Make it happen. Go on and study Australia with AMVPS. Let's make your future bright with AMVPS. Legal migration, education, pangarap ay maabot na. AMVPS, ang kasama mo.
One of the best feelings in life is having moments with the ones you love, even if you're far away from each other. Despite being 1,000 miles apart, our feelings haven't changed. Being beside you is a wish that I've long desired. With professional help, the long wait is over. Bridge the gap with Aussie Migration and Visa Professional Solutions. You can study, work, or live in Australia. With the help of our experts, you can fix your migration and visa application efficiently. Now, love doesn't have to be distant. Call us now.
If you have a dream, chase for it. Simulan mo nang abutin. Make it happen. Work and raise your family in Australia with AMVPS. Let's make your future bright with AMVPS. Ang migration, education, pangarap ay maabot na. AMVPS, ang kasama mo.
For inquiries, visit our website amvpsolutions.info and Facebook page Aussie Migration and Visa Professional Solutions.
A dream. Everyone has it. Distractions are everywhere, which makes us feel far from our dreams. Now, there is a way to close that gap. With AMVPS, we can take the one that's traveled by, and that has made all the difference. Whether big or small, our dreams are there to take us to write our future. Be a scholar now.
To learn more, visit our website at amvpsolutions.info. Like us on Facebook at Aussie Migration and Visa Professional Solutions.